Hello, everyone, and welcome to today's TASA Course and Trace webinar, a review of the resource guide to the U.S. FCPA Second Edition. My name is Sunny McCall, and I'm the Director of Compliance Training and Accreditation at Trace International, and your host for today's session. Our speakers for today's course are Billy Jacobson, partner, and Sarah Foley, compliance specialist, both with Allen & Overy. By way of background, Billy focuses his practice on FCPA and white-collar enforcement, representing corporates, individuals, and financial institutions. Billy has over 25 years of experience, having served as the Chief Compliance Officer and Co-General Counsel of a global oilfield services company, as a federal prosecutor, including as Assistant Chief for FCPA Enforcement in the DOJ's Fraud Section, and in private practice. Joining Billy today is Sarah. Sarah Foley is a highly skilled in global investigations, fraud, and anti-corruption compliance matters. She leverages her in-house experience in senior compliance roles to assist organizations with developing, implementing, and setting the strategic direction for global compliance and anti-corruption compliance programs. Sarah has conducted compliance trainings, investigations, and risk assessments throughout Africa, Asia, Canada, Europe, Latin America, Mexico, Russia, the Middle East, and the United States. For today's session, Billy and Sarah will provide a top-level overview of revisions made in the second edition of the resource guide, including updates driven by recent changes to case law, as well as DOJ and SEC policies. Before we begin, I would like to take a brief moment to remind everyone that Trace members receive free access to all live monthly webinars, as well as access to the full library of recorded webinars on the Trace Resource Center. To note, there will be live Q&A at the conclusion of today's session, so please do feel free to send your questions directly to me via the private chat function on the right of your screen throughout the session, as Billy and Sarah will be taking questions once they've concluded their presentation. To note, you will also receive an email after this presentation with instructions on how to access a copy of the PowerPoint slides. Please note that this webinar is being recorded, and the recording will be made available to Trace members on the Resource Center next week. Finally, for those of you joining us today who are licensed attorneys in the United States, Trace will be submitting this session for CLE accreditation in the following states only: Texas, Virginia, New York, New Jersey, and California. To certify to your attendance and engagement during the session, there will be a unique code that is shown during the presentation. Please note this code as you will be asked to provide it later on. Following the session, there will also be a survey deployed to attendees, which will request specific details that will be required to submit applications to the states to obtain credits. So with that, I'd like to thank Billy and Sarah once again for agreeing to teach this course and turn it over to them.
Thank you, Sunny. Thank you, Trace, for having both Billy and I. We are happy to be here today and talk through some exciting news in FCPA compliance. As a quick overview, the U.S. government's been pretty busy during quarantine. Early this summer on July 3rd, the DOJ and the SEC released its second edition of the FCPA guide, which is the first comprehensive update since it released its first edition in 2012. It remains a thorough compilation of very important information for both individuals and companies on how to prevent corruption. It also provides some very unique and interesting insights on how the DOJ and the SEC are looking at FCPA compliance through updated hypotheticals, references to enforcement actions that have occurred since 2012, as well as notable court cases that reflect some change in law since the first edition was released. While the general framework and context of the second edition is very similar to the first edition, Billy and I today will review some more notable updates to the second edition for you, such as the incorporation of some prior guidance and policies that the government has released since 2012. In 2019, as well as 2020, the DOJ released some guidance on how it addresses the evaluation of effective anti-corruption compliance programs. We'll discuss how that is incorporated into the second edition of the guide. As I mentioned, we'll talk through some notable enforcement actions that have occurred since 2012, as well as some legal cases. Not surprisingly, the internal accounting controls provision is pretty prominent in the guide, and we will talk through some references to it in the context of controls related to corporate compliance programs. And last but not least, we'll talk about M&A risk, as well as some successor liability call-outs that the DOJ and SEC include in this guide. So the first topic we will review with you will be the incorporation of prior guidance provided by the government. Billy?
Yeah. Thanks, Sarah, and thanks to Trace for having us. Thank you all for joining. Really happy to be here today. Wish we were in person at some point soon. Hopefully we'll all be together in person again. With regard to the incorporation of prior guidance and policy documents, since 2012, since the issuance of the first resource guide, DOJ has issued several policies and guidance documents, and they are incorporated into the second edition. No new policy is articulated in the second edition, but having all of the policies in one place is obviously helpful as a resource, so we don't have to go rifling through various documents. We have them all in one place. One of the policies incorporated is the evaluation of corporate compliance programs, as Sarah just mentioned, issued by DOJ in 2020, which was an update of a very recent memo from just 2019. Sarah will discuss that one in a few moments. As to the other policy documents incorporated, perhaps the most important is the FCPA corporate enforcement policy, which is set forth in Chapter 5 of the second edition. You'll recall perhaps that began life as the so-called compliance program, pilot program, I got my quotes wrong, in 2016 as a way to persuade companies to voluntarily disclose their corruption issues. DOJ had been telling companies for years that they should voluntarily disclose. I myself did so when I was at DOJ, but had really not been in a position to offer concrete benefits for doing so. The pilot program became enshrined as permanent policy in 2017, was made part of the Justice Manual, and is now part of the second edition resource guide. In short, the policy provides for a presumption of declination when a company voluntarily discloses a potential FCPA violation, cooperates thoroughly with DOJ's investigation, and remediates the problem in a timely way. There are, of course, exceptions, however. A declination is not to be presumed if executive management is involved in the misconduct, the company substantially profits from the misconduct, or the misconduct is pervasive within the organization, or the company is a recidivist. Nevertheless, the policy does provide benefits even for a company that doesn't meet all the criteria for a declination in terms of prescribed reductions off the company's fine amount. So, this always leads to the question of, given the corporate enforcement policy, should we voluntarily disclose if we find potential corruption in our company? And that's still a very open question in my mind, and depends to a considerable degree on the odds of the government discovering the misconduct, absent a disclosure, either through a whistleblower, the media, a competitor, or foreign government, or some other way. So while the corporate enforcement policy does provide real benefits for disclosure, the harm to a company is still greater via disclosure than if the DOJ and the SEC never find out about the action in the first place. So for what it's worth, my usual recommended course is to remediate the problem, fix internal controls, discipline wrongdoers, and then move on, unless there's a reasonable belief that DOJ is going to find out about it anyway. In addition to the corporate enforcement policy, we find a reference to the so-called no piling on policy in Chapter 6 of the second edition. This policy was articulated in 2019 and provides that when assessing fines, DOJ attorneys are to consider fines levied for the same conduct by other parts of the federal government and by foreign governments. This policy is now part of the Justice Manual, which guides how prosecutors are to behave and bring their cases. The policy and the principles behind this no piling on policy, which began to be implemented several years ago, have not resulted in lower overall fine amounts in FCPA cases, but have resulted in lesser amounts going to the US Treasury in favor of other governments. For example, when Odebrecht and Braskem settled in late 2016 with the US, Brazil, and Switzerland, the total fine and penalty paid was $5 billion. but only 10% of the criminal fine went to DOJ, with 10% going to Switzerland and 80% going to Brazil. Similarly, the Petrobras settlement saw 10% of the over $800 million fine go to DOJ, 10% to the SEC, and 80% to Brazil. Lastly, with regard to policies, the policy around the selection of monitors in criminal division matters was issued in October 2018. And that and previous monitor-related policies are incorporated into Chapter 6 of the second edition. The most important takeaways from this section are that in considering whether a monitor is necessary, DOJ should consider whether the misconduct at issue involved manipulation of internal controls or the exploitation of inadequate compliance controls, whether the company has made significant investments in its compliance program, whether remediation by the company has been done, and whether it's been tested. It is also DOJ policy that monitors are not to be imposed for punitive purposes, and that's put into the guidance document. The second edition contains a very helpful line at the end of this section where they say, quote, where a corporation's compliance program and controls are demonstrated to be effective and appropriately resourced at the time of resolution, a monitor will likely not be necessary, unquote. These are words that every company resolving a matter with DOJ ought to memorize and aspire to achieve in the course of the investigation, make sure that they can make that representation and demonstrate that to DOJ by the time settlement discussions begin, if in fact the matter is to be settled. So now let's turn to compliance programs. Many of you are compliance professionals, and so this might be the most important part of our hour here today. Sarah?
Okay. So maintaining an effective anti-corruption and compliance program, as Billy mentioned just a few moments ago, the DOJ released guidance intended for its prosecutors focusing on the evaluation of corporate compliance programs. An initial version of it was released in 2019, and in June 2020, they released an updated version of that. Like I said, the guidance is intended for prosecutors as they look at how to address resolution and any sort of post-compliance obligations post-settlement for companies. This guidance really does focus on how compliance programs are constructed, how they're implemented, how they're resourced, as well as how they're reinforced throughout the entire organization. In addition, and really centered within the June 2020 evaluation of corporate compliance programs guidance, there is a central focus around three important questions specific to the effectiveness of a corporate compliance program. The first question being is, how well is your corporate compliance program designed? The second question, is it applied earnestly and in good faith? And is the program actually working in practice? And throughout this guidance, which we see carried over into the second edition of the guide, DOJ really wants a company to look at its risk profile, how it goes to market, its industry, what its operation locations are, in order to make sure that it is able to implement and maintain a compliance program that is fit for purpose, fit for that organization. Because as we all know, compliance is not one size fits all, and there is a multitude of criteria that legal and compliance professionals need to consider when standing up an anti-corruption compliance program. As I mentioned, we see in the second edition, the DOJ and the SEC basically carry over the guidance that is in the DOJ's June 2020 document and evaluation on corporate compliance programs into the second edition. So we see the same themes that are included in the June 2020 guidance peppered throughout this section within the guide. A few important call outs though to highlight for you. In the second edition, there is a new section on investigation, analysis, and remediation of misconduct. This section really focuses on the investigative function within an organization. For example, is there a confidential and anonymous reporting mechanism? How is the company resourcing and funding its investigation function? How is the company working on documenting and making sure that remediation and disciplinary measures are implemented effectively? And most importantly, how are compliance programs taking the information that you learn through an investigation, taking those lessons learned and looking at gaps and areas of enhancement that should be a focus for the company going forward in the context of compliance? This call out with respect to investigations in the second edition of the guide is very similar to a call out that the DOJ made in its guidance regarding the effectiveness of corporate compliance programs, in that there is a specific reference to the actual expertise of a company's investigators. So while we call out these particular topics that we see in the second edition of the guide, I think an overarching and very important theme to recognize is the DOJ and the SEC are focused on the effectiveness of a compliance program and how a company is looking at its compliance program from a continuous improvement lens. So taking learnings from whether it be investigations, due diligence activities, trainings, etc., applying that to its compliance program to make sure that the right improvements are occurring and that certain resources are devoted in an appropriate way to the organization. A notable reference within the second edition of the guide is that the DOJ does call out that effectiveness and, quote, lessons learned are the truest measure of an effective compliance program. So really reinforcing just the need to take a look back, do a gap analysis, look at those lessons learned, and see how you can improve your compliance program, taking obviously a risk-based approach to that.
Yeah, and if I could just add, the second edition's discussion on compliance is leaps and bounds more mature and sophisticated than the first editions, reflecting DOJ's increased learning, DOJ's own sophistication. DOJ essentially sits listening to companies pitch about how great their program is, case after case after case, as companies try to benefit from things like the corporate enforcement program and so forth. And so they get to learn all the best practices that companies who are really at the other end of the nozzle facing the DOJ have implemented. And so in some ways it's a little unfair, because in some ways DOJ has sort of a best of, and they may want to impose that upon companies before them. Certainly upon well-resourced companies. They do allow that small and medium-sized companies could be given some leeway and would have to, that DOJ will be practical in how they assess small and medium-sized programs. But for large companies, they sort of expect this best of approach as they articulated in the 2020 guidance and as they articulated in the second edition of the guide. So it's definitely, for those compliance professionals out there listening, it's definitely worth taking the time and looking both at the second edition, this compliance section of the second edition of the guide, as well as the revised memo that came out just a few months ago regarding particularly just compliance programs.
Mm-hmm.
Yeah, now I think oh, go ahead, Sarah, sorry.
I was just going to say, I think for the compliance professionals participating today, an important example that the second edition of the guide included is reference to the Morgan Stanley case, where the company took really robust steps to address misconduct and potential compliance risks related to activities by an individual executive. And that's always served as a pretty good example from a compliance program standpoint, because the DOJ and SEC ultimately declined to bring enforcement actions against the company because of those compliance efforts.
Right. So moving forward to discussions of case law and case examples on slide 7. So the second edition does a nice job of incorporating cases that have been settled and decided since 2012. The first edition cited to cases as examples to illustrate various principles articulated by the government, examples of travel and hospitality, examples of who is a government official, etc. And the second edition updates those examples to keep the resource guide current. Most of the references are to settled cases, cases not challenged by the courts. And so they serve as ready-made examples for DOJ and the SEC to make their points, because DOJ and the SEC wrote the settlement documents. They were subject to some negotiation, but they wrote the settlement documents, so they are easy for DOJ and the SEC to reference as examples. In addition, and more interestingly to me, the second edition offers explanations and commentary on some judicial decisions handed down since 2012. And those are more interesting, of course, because DOJ and the SEC don't get to write the judicial decisions as much as they'd like to. And so judges who are obviously more objective get to do so, or at least we hope they are more objective. So one set of cases discussed is the limitations on the power of the SEC to seek disgorgement of profits. That's discussed in Chapter 2. The guide notes that the Supreme Court decision in Kokesh, a case called Kokesh, where the question before the court was the applicable statute of limitation for an action for disgorgement. How long does the SEC have to bring a case for disgorgement of profits, of a company's profits? And the court found that disgorgement is often a penalty as opposed to being an equitable remedy, as the government argued it is. And because it's a penalty, and because the FCPA does not contain any sort of statutes of limitation particular to disgorgement, then the normal civil enforcement penalty contained in the US Code will prevail, and that's a 5-year statute of limitations. So that tells us that the SEC has 5 years to bring an action for disgorgement. Then more recently, just in this year, the guide also notes the recent case of Liu versus the SEC, in which the SEC's very ability to win disgorgement at all was challenged. And the court found, as I said earlier this year, that disgorgement was available to the SEC, but only if it is an equitable remedy, not if it's a penalty, which the Kokesh case had said it often is a penalty. And so the court said disgorgement would be available if it's an equitable remedy, meaning if it compensates actual victims, as opposed to the money just going to the US Treasury, it is limited to the company's actual profits. And so any sort of deducted, overhead is deducted. And it's limited to each individual defendant or each individual company's own profits, and not the profits of other defendants, maybe partners, based on a theory of joint and several liability, which had been done in the past. So that is a kind of a profound change with regard to disgorgement and what qualifies as legitimate disgorgement and what the SEC is thereby able to do. The second edition, interestingly, does not include a discussion of a case called Gabelli versus SEC, in which the court found in 2013 that the statute of limitations for civil penalties brought by the SEC, as opposed to disgorgement, but civil penalties, statutory penalties, begins running when the offense occurs and not, as the government argued, when it's discovered. Now, Gabelli was not an FCPA case, but nevertheless will be applied to FCPA cases. So the second edition does not, and this is understandable, I think, from the government's perspective, explain that together, these three cases promise to really have a substantial impact on how and whether the SEC brings FCPA cases going forward. First, as per the Gabelli case, the SEC must bring a case for penalties within 5 years of when the misconduct occurs. And it's worth thinking about this in the context of an FCPA case, because the SEC does not benefit from the use of a conspiracy statute the way that the DOJ does. So let's say we have a long-running bribery scheme, 15 years. The DOJ is able to wrap all of the bribes from that period, from 15 years ago, 10 years ago, and 5 years ago, into one conspiracy. The SEC, however, as per Gabelli, must charge each separate bribe not more than 5 years after it occurred. So if it doesn't learn about the entire scheme until 15 years after it began, it's really going to limit what the SEC can charge. Second, as per the Kokesh case, the SEC cannot get disgorgement of profits that were earned more than 5 years before the suit is filed. So using our 15-year example, if the company's been making profits for 15 years, the SEC is only able to achieve disgorgement of the profits earned in those last 5 years, which could be substantially less, could be more, but could be substantially less than the previous 10 years, depends on the circumstances. Third, the SEC will have to figure out a way to compensate victims with disgorgement, which will be really tricky in FCPA cases. The government, the US government, has always struggled with the idea of victims in FCPA cases. The actual victims are, in most cases, the citizens of a country whose government was corrupted. But how do you get the money back to those citizens? Would you have to go through the same corrupted government, or is there some other way? The DOJ, neither the DOJ nor the SEC has really figured this out. And I'm sure it's something the SEC is wrestling with now, because given these cases, it's a more pressing concern for them. Another area of the law updated by the second edition is the definition of an instrumentality of government. That's in Chapter 2. You'll recall that the FCPA provides that employees of government instrumentalities are foreign officials under the statute. Thus, the DOJ and the SEC have long considered employees of state enterprises, such as Pemex and Petrobras, to be foreign officials. In 2014, an appellate court endorsed that view for the first time, and the second edition contains a discussion of that. This is the Esquenazi case, where the 11th Circuit agreed with DOJ that a telecommunications company owned by the government of Haiti was an instrumentality of the state, and so its employees were foreign officials under the FCPA. Thus, if they were bribed, it was a violation of the FCPA. And the court found that an entity is an instrumentality of a government if it is both controlled by the government and performs a function the government considers its own. The court then listed a series of criteria it would consider in making this determination, such as the government's formal designation of that entity, the level of ownership, interest by the government's ability to hire and fire the entity's principals, and so forth. In addition, the second edition speaks to the local law defense, a little discussed affirmative defense contained within the FCPA that would apply if a defendant can establish that his conduct was legal under the written laws of the foreign country at issue. The defense is little discussed because it's of so little relevance. It's almost never applicable. And the second edition references a 2017 case out of the Southern District of New York, the Seng case, S-E-N-G, to make that point. And then lastly, in terms of case law, the recent Hoskins decision relating to the long-running Alstom series of cases is also referenced in the second edition. In Hoskins, the Second Circuit found that a foreign national was not covered by the FCPA, could not be charged with conspiracy to violate the FCPA or with aiding and abetting a violation of the FCPA. And the distinction here is that a non-US citizen is subject to the FCPA, essentially if he or she acts corruptly in the US or is an agent of a US domestic concern, a US company, or an agent of a company that's an issuer in the US and uses the mails and wires of the US in furtherance of a corrupt scheme. DOJ apparently believed it would have difficulty proving agency with regard to Hoskins, and so charged Hoskins with conspiring to violate the FCPA, not with the substantive FCPA offense, but with the general US conspiracy statute, which is 18 U.S.C. 371. The court, however, found that Hoskins could not be convicted of conspiring to commit the FCPA if he could not be found to violate the substantive statute. And while both the conspiracy statute and the general aiding and abetting statute under US law are usually really liberally construed, allowed under almost any circumstances by the courts, this court found, this is the Second Circuit, found that the FCPA specificity with regard to who is subject to the FCPA, because the statute goes into so much detail about what individuals and entities are subject to the FCPA. The court found that specificity means that anyone not enumerated could not be charged with the FCPA, and then it could not be charged with conspiracy or aiding and abetting the FCPA. So the DOJ was obviously not happy with this decision, and in the second edition, interestingly, goes out of its way to note that at least one court outside the Second Circuit has rejected the reasoning in Hoskins, leaving it an open question in theory as to whether DOJ will charge a defendant pursuant to this theory outside of the Second Circuit going forward. And though a lot has been written about Hoskins, A, because there's so little law being made around the FCPA, actual law, and B, because it's sort of a nerdy, interesting issue, to us FCPA nerds. Personally, I feel it will have little practical impact on FCPA enforcement, as in most cases, the government can readily prove, if it finds someone is culpable, could readily prove that that non-US person was an agent, either of a US company or of an issuer. So despite all the discussion, I really don't think it's going to impact actual enforcement cases all that much.
So the next topic we wanted to discuss today is the internal accounting controls and just in the context of compliance programs, which is teased out a little bit more in the second edition of the guide. So naturally, the FCPA's internal accounting provision plays a very prominent role throughout the guide. And these provisions are focused on companies making sure that they maintain accurate books and records, as well as effective internal accounting controls. The nature and seriousness considered when determining whether to pursue enforcement actions, DOJ and SEC will look at that. We'll look at the nature and seriousness of potential violations of this provision, specifically determining whether to proceed with an enforcement action against a company. The guide also acknowledges that maintaining effective internal accounting controls can also help companies prevent unethical conduct or misconduct involving non-FCPA related matters, such as commercial bribery, addressing trade compliance requirements, as well as embezzlement. In looking at the second edition, however, we noted that throughout this particular section, the DOJ and the SEC start to distinguish when they reference between internal controls and internal accounting controls. Therefore, noting that a company's internal accounting controls are not synonymous with a company's compliance and controls related to a company's compliance program. However, they acknowledge that those can indeed overlap. It goes further to recognize that the effectiveness of a company's overall control of environment relies on what they describe as operational realities. Similar to what we discussed in the context of effective corporate compliance programs, the government's looking at how a company will implement an effective control environment, taking into consideration industry risks, operating model, go-to-market strategy, what level of government interactions you may have in your day-to-day operations. It also carries over from the first edition of the guide, language on liability for both entities and individuals related to violations of this specific internal controls provision. All that to say, in the past, the DOJ and SEC may have been conflating a bit, somewhat, the internal controls provision to carry over from what is probably intended to be an accounting control focus area, interpreting that broadly to encompass the controls that are associated with an anti-corruption compliance program.
Yeah, and it's interesting to note that one thing that the internal controls portion of the second edition does not contain is cites to any decided cases. That's because there are none. The internal controls provision has never been interpreted by any courts. And personally, I'm dying for a company to challenge the breadth of the internal controls provision as it's been applied by the SEC, because even though they've recognized in the second edition that internal accounting controls are not always synonymous with compliance controls, in practice, they haven't acted that way. In practice, they've acted as if they are synonymous. And they've really ignored the word accounting that comes between the words internal and controls. It's obvious that not all controls are accounting controls. And commentary on the statute made by the SEC chairman at the time the FCPA was passed indicates that the provision was intended to be interpreted narrowly. On the contrary, one of the Princeling cases from a few years ago, remember there was a series of cases against banks for hiring sons and daughters of prominent Chinese officials, known as the Princeling cases. And one of the Princeling cases brought a few years ago referred to, quote, internal accounting controls around hiring practices. Internal accounting controls around hiring practice. I have no idea what that means, but it's certainly not a narrow interpretation of the internal accounting controls provision. One more point and then I'll get off my soapbox. The other words that the SEC really reads out of the statute is the phrase reasonable assurances, as in a company must devise and maintain a system of internal accounting controls sufficient to provide reasonable assurances that bad things don't happen. The SEC has not hesitated to bring internal controls provisions charges whenever really something untoward has occurred, regardless of whether the controls at issue did provide a reasonable assurance that payments would be controlled, but failed or were circumvented, because reasonable assurance does not guarantee perfection and was never intended to. So these are, of course, points that the second edition don't make, but I thought were interesting for discussion. I'll step off my soapbox now. Let's continue.
Okay. So moving on to the last notable observation that Billy and I wanted to review with you before we get into key takeaways from the second edition. Really, it's focused on M&A risk and successor liability. So the second edition, like the first edition, continues to focus on the timeliness and how robust due diligence is prior to an acquisition or partnership, as well as the post-acquisition, post-partnership with a joint venture, for example, integration activities, as well as the voluntary disclosure of any sort of potential or actual misconduct that occurs during these types of activities. The second edition highlights when a parent entity can be held liable for an FCPA violation, specifically if the parent obviously participates directly, or if the subsidiary or the target or partnership is acting as an agent under the authority of the parent. Additional language that the DOJ and SEC include within this section of the second edition is acknowledging that there are commercial and strategic positives that come out of an M&A activity or a joint venture partnership. However, notwithstanding the need to conduct robust due diligence, if possible, the DOJ and SEC will look at how robust the acquiring company's compliance program is, and if due diligence is not able to be performed in a robust manner prior to an acquisition, how quickly that acquiring company will extend its compliance program to that other entity and integrate it, bring it within the fold of this broader global compliance program. The government will assess, of course, the timeliness and thoroughness of any sort of post-acquisition due diligence, and notes pursuant to the FCPA corporate enforcement policy that the acquiring company could potentially be eligible for a declination if during these due diligence activities, whether pre or post transaction, they identify misconduct and report it in a timely manner to the government. Again, the second edition, like the first edition, continues to reemphasize the importance of the expectation of due diligence related to these sorts of transactions. Again, the timeliness, how prompt it occurs, how the parent will extend compliance expectations to the other entity, any sort of assessments or audits and monitoring that's implemented for the new business, and then also compliance training that's provided to key stakeholders and employees on the parent's anti-corruption requirements and expectation, how that is provided to new employees that join as part of this sort of transaction.
Yeah, and I think with regard to M&A, the new guidance in the second edition again shows DOJ's maturation in terms of compliance, and I think of M&A due diligence really in terms of compliance. They've seen a lot over the past 8 years since the first edition came out, and they realize that the realities on the ground are not what maybe are not perfect, and they're not what they would hope for in sort of the ivory tower view of the world. But there are circumstances where diligence is not possible. There are circumstances where diligence, in order for a company to be competitive, has to be limited, and they're allowing for that sort of commercial reality to happen, while also saying, okay, but if that happens, these are the things you need to do. And it seems somewhat fair and balanced and mature and sophisticated, frankly, in my view.
So Billy will transition to key takeaways.
Yeah, so essentially, I think the second edition is a really valuable resource that packs a lot of law, policy, and learning into one document. I really feel it was really well done by the DOJ and the SEC. I think it, like the first edition, the second edition took a ton of work. And to their credit, the DOJ and the SEC lawyers spent a lot of time, obviously early on during the quarantine period, doing really good work. So they should be patted on the back for that, I think. The second edition does not break new ground, but that's okay. It wasn't intended to do so. It was intended to really survey the old ground. And the group, the FCPA group in both agencies has certainly been super busy in the last 8 years. If there's a point of criticism to be had, it's perhaps that the guide could focus a little more on relevant aspects of foreign law, given that so many of these cases are being brought and settled these days by non-US regulators like Brazil, Germany, Switzerland, France, UK, the Dutch, all being increasingly active in this space. Nevertheless, I could obviously understand how a US lawyer would not want to risk missteps by talking about foreign law. There is some touching in the second edition on how the regulators are across the world are interacting and cooperating with one another vis-a-vis the OECD working group on bribery and otherwise. And there's some discussion on MLATs, but it's understandable that they wouldn't necessarily want to get into issues of foreign law. Where the guidance is maybe the most helpful, as with the 2020 compliance guidance itself, is with regard to compliance. I don't want to repeat myself what I said earlier, but that section definitely deserves lots of your study and attention, and as does the June 2020 compliance memo itself. So with that, we've got about 15 minutes, and happy to answer questions. Sunny, I don't know if people have submitted any questions.
Yes, absolutely. We have had a few come in. Billy and Sarah, thank you so much for the presentation. Just as a point of reminder before we go into the Q&A, for everyone who does need CLE credits, please do stay on the line with us because we'll have a few quick polls for you to respond to once we're done here. So first question to both of you, is a company with global operations, including a subsidiary in the U.S., subjected to the FCPA if the company is not a U.S. issuer?
Yeah, that's a great question. Certainly the subsidiary in the U.S. is subject to the FCPA, and the government, in order to exercise jurisdiction over corruption by that company, would have to tie it to the U.S. somehow. So if the company is entirely in, let's say it's based in China, and it's the Chinese part of the entity that engages in corruption, it has nothing to do with the U.S. subsidiary. Wires and mails of the U.S. are not used. Personnel from the U.S. are not involved. The DOJ would have a hard time exerting jurisdiction. There are cases where the DOJ will exert jurisdiction just on the basis of money, U.S. dollars, being used in transactions, which is quite common outside the U.S. And so that could be a jurisdictional hook to be wary of. But generally, from sort of a compliance perspective, the answer is most likely no, with the exception of the U.S. subsidiary.
Perfect. Thank you, Billy. Next question. What are the conditions of FCPA territorial application? For example, is it mandatory to have an agreement between a company registered in the USA and another country?
I'm not sure I understand that question. Sarah, did you understand that?
No, not entirely.
Can you read it one more time, Sunny?
Yeah.
Sure. What are the conditions of FCPA territorial application? For example, would it be mandatory to have an agreement in place between a company registered in the U.S. and another country?
Yeah, I don't understand the second part. With regard to territoriality, and the SEC and the DOJ exerting jurisdiction, it really is essentially the same answer as I gave to the first question, which is there has to be some nexus to the United States. Either people acting as agents of a U.S. company, agent of a U.S. issuer, that is a non-U.S. company but that trades on the U.S. exchanges, or someone is actually acting in a corrupt manner while physically in the United States.
Got it. Thank you for that, Billy. And certainly for the person that asked that question, Billy and Sarah have been kind enough to post their direct contact details. So possibly easier to address that one directly one-to-one. Next question for you both. How do some of the key points addressed by the government in the second edition trend with or against the evolution of global anti-bribery regulation and enforcement, in your opinion?
Sarah, do you want to take that one first?
Sure. I think, over the years, the different stances that the DOJ and the SEC have taken on FCPA compliance and enforcement actions, we're seeing a lot of international regulators follow suit pretty quickly behind. If you look at some of the international anti-corruption regulations that are now in place, whether it's Brazil, Mexico, other jurisdictions, we're seeing a lot of commonalities between that and the FCPA. Maybe not directly, but just generally from a principle standpoint, we are seeing a lot of overlap. And so I think to circle back and answer the question, I think DOJ and SEC with their enforcement and FCPA compliance commentary with respect to compliance programs, I think we're seeing international regulators follow suit fairly quickly behind them.
Yeah, I agree, and it really mirrors what the what the U.S. has done with regards to enforcement since the FCPA was passed in 1977, realizing the U.S. government realized that we didn't want the U.S. to be alone in forbidding the bribery of foreign government officials, because it would put U.S. businesses at a horrible competitive advantage outside the U.S. especially in sectors like oil and gas and energy and pharmaceuticals and medical devices and so forth. And so the U.S. government really pushed through the Commerce Department and the State Department and to the through the Department of Justice, of course, pushing the OECD to pass its treaty, which required OECD member countries, which are now 40 some odd, to pass a foreign bribery statute. And then pushing the OECD to form a working group on bribery, where these countries get together and they discuss and criticize each other for their, based on their statutes. Maybe there are some holes here or there based on their enforcement. Why isn't this country doing anything, even though it has a statute? So the U.S. has really been taking the lead ever since 1977 in terms of foreign bribery. And this guide, like Sarah said, is continued evidence of them doing so. It won't be surprising at all to see, say, the UK Ministry of Justice follow on with something similar, especially with regard to the compliance guidance from 2020. And the OECD may be following on. They already have some, but maybe enhancing theirs. And other countries, Brazil is a great friend of the DOJ and the SEC these days. The Brazilian MPF and the AGU and the CGU. Wouldn't be surprising to see them enhance the guidance that they've put out so far. So yeah, totally agree.
Perfect. Well, Billy and Sarah, thank you so very much. That definitely concludes this portion of the webinar. Thank you so much again for agreeing to lead the session. Of course, for anyone listening here, if you have something that's maybe more appropriate for a one-to-one follow-up, please do definitely feel free to reach out to Billy and Sarah directly on behalf of Trace. Billy and Sarah, thank you again so much for taking time away from your schedules. I'm sure you've been very busy advising clients on all these various points coming out of the guidance. So we appreciate your participation and support as always.
Thank you.
Thank you.
Thank you so much. So for everyone now, we're actually going to turn now to our CLE poll. Again, this is for anyone wishing to obtain continuing legal education credits for today's session. For all others, you may now leave the session, and we thank you again so very much for joining us today and for your participation. So with that, we'll now go ahead and launch our first poll question. Okay, our second CLE poll question. Okay, and finally, our third poll question. Okay, this now concludes our CLE poll. Again, thank you so much, everyone, for joining us today. Please do expect outreach from a member of our accreditation team to obtain your state bar information, which will be required to apply for CLE on your behalf. Thank you again so very much to Billy and Sarah for hosting today's session, and thank you again to all of you for taking time away from your sessions to join us. We hope that you all are keeping well and staying well. Please do be on the lookout for additional information to follow. Trace will be hosting some virtual events coming up here in the coming weeks and months. So please do feel free to be on the lookout for more information and details on those. And of course, we will also continue to have our webinars coming to you on a weekly basis. Thank you so much, everyone. Please stay well. Talk to you all soon. Bye-bye.